you so much for inviting me to be part of this program with so many incredible speakers, including legislative leaders. And I especially want to thank Jean and the Office of Dispute Resolution, which is truly a trailblazing program, and one that I've had the pleasure to read and talk about over the years. And of course, we also are approaching the 2021 legislative session, and thankfully nothing has happened since the legislature last met. But the reality of it is obviously a lot of challenges are confronting lawmakers as they prepare to reconvene. And of course, some of those relate to criminal justice. And so I'd like to talk a little bit about how the pandemic and the other events of this year have impacted the criminal justice system, and what some of the steps that lawmakers can take to hopefully continue to improve public safety. Also, taking steps that will benefit taxpayers, victims of crime, and reduce recidivism, keep families together, reintegrate folks into the workforce, all the priorities we've pursued over the last 15 years, really. So, but before I get into some of those matters, since we are here mainly to focus on mediation, I wanted to, of course, provide the obvious good news, which is the very success and existence of the program in Lubbock demonstrates that, there's other jurisdictions around the state that can learn from that and implement a similar mediation program without any legislation. Several sessions ago, just to further clarify that point, we did work with Senator Charles Schwertner and other lawmakers to pass a provision that was added on to the civil ADR statute, which simply said that criminal ADR can be done, and it didn't impose any restrictions on it. I think that relatively few people probably are aware of that provision. But, and there have been bills over the years that explicitly would create a victim offender mediation statute. And certainly we've always felt like there's some benefit in actually having, that phrase expressly in statute. But on the other hand, there's also been a real concern about making sure, a legitimate concern, that any existing programs would not in any way be preempted by anything the legislature might do. And, I think that when you look around the country and even to places like New Zealand, where mediation is most common, there are differences in how mediation can be structured. And I think we've always had the view that we should let many flowers bloom, and we shouldn't prescribe particular details out of Austin or let alone Washington, D.C. So, the Lubbock program is somewhat different than other victim offender mediation programs, some other ones, because some of the other ones require a lot of preparation, hours working with the victim and the offender before there's a meeting. And of course, the TDCJ program, which isn't limited to family members who are family members who's had a victim in their family of homicide, but as it's turned out, all or nearly all of the participants have fallen into that category. And that's a much different situation. You want a lot of preparation. The consequences of a meeting not going well are really terrible to think about for the family. But of course, that's a totally different context. It's not a mediation to resolve a case. It's a mediation for the surviving family, or if, again, it's eligible for other offenses. So you could have victims not in homicide cases themselves be part of those, choose to go through that mediation. But it's not for resolving a case, but to really address questions that survivors or victims or family members have, like why was I targeted, or why was my family member targeted, and things like that, that only the offender can answer. So, of course, the other thing in that context, it's very clear who the victim and the offender are. And even in some of the pretrial programs that are different from the one in Lubbock, it's very regimented that way. Whereas, of course, in the Lubbock program, you can have a dispute that a police officer might encounter and refer both people to this, where it's not entirely clear, who the victim and the offender were. Both people may have had a bit of a tangle of some kind, or a dispute, and the officer may determine the best way to resolve that, especially perhaps because of the lack of clarity about who's at fault, or if both people are at fault, is to make a referral to mediation. So I think there's a few things that kind of follow from the structure of the Lubbock program, which if not unique is perhaps not as common as you look out on, as common as a traditional victim offender mediation model. But one of those really has been the volume of the cases that Lubbock's been able to handle. And I think one of the other things that really stands out is really just eliminating friction that can reduce the incentive for whether it's prosecutors, police, to make referrals. One of the things we've encountered in previous legislative sessions when victim offender mediation has come up is that prosecutors, the association, and probably most of them that they speak for, want to be the sole gatekeeper on what cases can go to mediation. Now, I'm not counting police referrals. I think that they don't take that position there. But once a case has gotten further than that, you know, charges or someone's gone to jail, something like that, they don't believe like that they should be able to trump what the prosecutor wants as far as going to mediation. So one of the consequences of that is that certainly the vast majority of cases, over 95% in the criminal justice system, are resolved by plea bargain, not going to trial or that sort of thing. So particularly as it relates to low-level misdemeanors, many prosecutors in Texas have said, look, we plead these cases out so quickly, there's not even time for us to determine whether it would be suitable for mediation. But of course, I just said earlier that they want to be the sole gatekeeper. So you can see how there can be a bit of a tension there. So I think the Lubbock program has really transcended all of that through the cooperation with the prosecutors there, the police, school police make some referrals. So, I mean, it's just logical from an incentive standpoint that if you have that level of buy-in and you don't have friction and you don't have many hours of preparation that have to be done for each case, that you can achieve a substantial scale. And that's exactly what's happened. So I think that makes it very attractive for other jurisdictions to try to put this into place. And certainly, while they can't clone Gene and the other staff there, there's a lot that can be learned from it. And so I'm really, really optimistic that through this session and individual outreach efforts that other counties in the state will move in this direction. So with that being said, I wanted to just talk a little bit about especially how the pandemic has affected the criminal justice system. And I do think these two conversations are related. Certainly, the pandemic has made, for one thing, police officers less inclined to make custodial arrests and book people in jail when they have other alternatives. So we've seen, for example, a substantial decline in marijuana arrests and jail bookings, which of course is one of the offenses covered under the 2007 cite and summons law that we work with Governor Perry and other legislative leaders on. So more jurisdictions have taken advantage of that in recent months. Of course, the only unfortunate consequence of that has been the Indigent Defense Commission, which relies in part on both traffic ticket revenues and marijuana revenues, because there's been fewer cases of both. They have seen a decline in resources. But the so of course the mediation referral, especially when it comes from an officer, is an off-ramp and is an alternative to bringing people to jail. So, and also I think it's a way to diffuse situations that could eventually lead to a more substantial charge that leads to jail bookings and the like. So I do think that the expanding mediation is one of many things we can do to respond to the pandemic. And I also think that there's a lot of the innovations that have come about as a result of the pandemic are things that we need to keep doing to some degree. Obviously, we want to resume in-person juries with appropriate safeguards, and we need to do that. There's a right for the accused to confront their accuser and so forth. So we're not proponents of moving all jury trials to Zoom trials. In some minor cases, it may be viable as a kind of temporary measure. But what we've really focused on instead is probation and parole reporting, which has largely moved to virtual reporting in Texas, not by fiat, but just by practice, as well as pretrial, routine pretrial reporting and hearings that has also gone in that direction. And of course, where appropriate, agencies are continuing in-person contact for things like drug testing, and also some probation departments will, for high-risk individuals, they will come out with a probation officer and they may stand 15 or 20 feet from them in their driveway to have a discussion. But the vast majority, particularly for low-risk individuals in both the pretrial, probation, and even parole context in Texas, while there's not data on it, it is largely moved from all anecdotal reports to a virtual reporting. And some of the data that we have seen from other states is really instructive, that we've seen since probation departments and pretrial in New Jersey and Michigan moved to virtual, they've had a huge decline in failures to appear. And a lot of that seems to kind of just reflect previous research showing very few people intentionally abscond, but rather for court hearings and appointments with their probation officer, it's more likely that previously that they didn't come because they didn't have childcare, they were sick, they couldn't get away from their job, and so forth. And actually, one of the other things that's really encouraging is we're seeing the use of apps where someone can say in advance, look, I've got this type of issue came up, can I reschedule my routine hearing or my appointment with my probation officer? So that's a very, very positive development as well. So I think some of this increased reliance on technology can be very helpful, although we do have to bear in mind certain inequities. And I think particularly relevant when we look at West Texas, rural areas where people may not have high-speed internet. So we don't want to have people be disadvantaged by virtue of that either. So it's important to implement it in an equitable way and take into account people's resources. But again, that is encouraging. And of course, that has been a contributor to a decline in the prison population. Texas is now at 121,000, which is more than 40% reduction in incarceration rate relative to our high, which was obviously roughly 20 years ago. But there's been a steep decline in the prison population since the pandemic began. It's gone from about 141,000 to 121,000. Now, it's very important to emphasize that as a result of fewer admissions. There have not been any changes to release people earlier from prison. And in fact, quite the contrary, there's thousands of people in prison who are waiting, who have been approved for parole, but are waiting for a program to complete a program. And the lockdowns, which have gone down, thankfully, the number of prisons that are on lockdown, but that combined with correctional officers and treatment providers who are either in quarantine or have absences relating to COVID, that has delayed the completion of some of these programs that are a condition of release even after someone's approved for parole. Now, the good news is TDCJ recently tablets that are being used for video visitation as well as for completing some of these programs like cognitive behavioral therapy, drug education, and so forth. So I do think the agency, in a very difficult scenario, has taken a number of steps, obviously including making hand sanitizer, $30 million for COVID testing. So certainly any type of correctional environment is very challenging from a social distancing perspective. So, but I think that certainly there does appear to be some progress being made in several areas as it relates to COVID in the state prison system, but it is still a significant challenge. So as we look towards this session, we're obviously very cognizant of the budget realities and what we can do, consistent, of course, with public safety, to really, I would say, learn from what happened in 2003. And I actually wasn't working in this area then. I think I was in college or law school. But the reality is in 2003, the legislature, facing a recession that was kind of a tech recession, decided to not make any changes to sentencing reform or anything that would reduce the prison population or stop it from continuing to increase at that point. And instead, the legislature cut probation by about 20%. And what immediately followed that is the late Ray Allen often said, who was chairman of the corrections committee at that time, that literally as soon as those cuts were announced, they started seeing an increase in people being revoked from probation as caseloads went up and people that were long waiting lists, if somebody wanted to get into a treatment program. And of course, we didn't have the level of drug courts that we have now. So, as these probation caseloads became unmanageable, officers were more likely to revoke people for technical violations, which is still about, before COVID, about 11 or 12,000 people every year revoked from probation in Texas for technical violations, plus another 11 or 12,000 for new crimes, some of which are misdemeanors, could be even marijuana. Now, both of those sources of revocations have, it seems, we don't have the data, but it seems anecdotally have significantly, especially technical revocations, significantly declined since COVID started. And of course, in the initial months, TDCJ wasn't taking anyone, even who had been sentenced. That, of course, was loosened a couple months ago. So, but there's still some people, of course, waiting in jail, and then there's many trials that are on hold. So there will be an influx of people that are in terms of prison admissions. So we do expect the 121,000 number to go back up to some degree, although also balanced off as people approved for parole go through those programs I referenced. So, but essentially from a budgetary perspective, we don't want to repeat what we did in 2003, which was to cut probation and set the stage for what many people may remember. In January of 2007, the Legislative Budget Board estimated we would need to build 17,000 prison beds by 2012. And that precipitated the shift in that budget that year that Chairman Whitmire and my colleague, former Corrections Chairman Jerry Madden, really led. And Governor Perry in his State of the State speech that year said we need to take a new approach instead of just continually building more prisons. And again, it was really a budgetary shift, putting $241 million into alternatives, as well as in-prison treatment programs, instead of spending a few billion to build these additional prison beds. And lo and behold, we ended up closing what will be by the end of this year, at least 10 prisons. So we've overshot what the initial goal was to just stop building more prisons. So all of that, looking towards this session, as I kind of hinted at, probation reform is one of our priorities, particularly to require that graduated sanctions be used to deal with technical violations. So if somebody misses an appointment, or if they drink alcohol, again, assuming they're not, on there for drunk driving or something, but they have a technical violation that's not related to public safety, not something like violating a no contact victim, but something that's just to the many, many terms of probation. The technical violations are things you or I could do that are perfectly legal, but because someone's on probation, they can't leave the county without permission. And again, I'm not trying to minimize it. There have to be consequences, but what the research has found is if you give somebody a curfew or even electronic monitoring or even a weekend in jail, it actually is just as effective, because it's the swiftness and the certainty of the sanction rather than the duration that changes behavior. And positive incentives, earning your way off of probation, is even more effective than these graduated sanctions. So that legislation, which did pass the House in some form last session, is a really high priority and has been effective in many other states. So one of the other areas is drug sentencing reform. In Texas, it's a state jail felony to possess less than a gram of drugs, even a trace amount, which in many cases can't even be reliably tested more than once. There were many hundreds of cases in Harris County that had to be corrected because the test said somebody had drugs, but in fact it wasn't illegal drugs. I think the majority of Texans from polling that has been done believe that, if you just have a very small amount of drugs and for personal use, that should not be a felony. And so one of the proposals next session will be to in fact reduce that to a Class A misdemeanor, still punishable by up to a year in jail. But really the goal is to get people in pretrial diversion. And that's, we've seen Harris County and many other counties embrace that. And we now have the data from Harris County, which shows comparing people of the same risk level, the same offense history, who go to pretrial diversion drug treatment overseen by the probation department versus people that went to state jail. Over several years, the recidivism difference is stunning. It's 2 or 3 times more recidivism for the people that went to state jail. And they only stay typically for several months, especially if they already accumulated time in county jail because they couldn't afford bail. So there's not even enough time to get them into a program if there was a program. And so what we've seen, and this is actually similar to what's happened with marijuana, the cases have gone down. I recently spoke with folks at TDCJ. There's just a couple thousand state jail felony people there now, and it was once 20,000. I mean, it's just remarkable. So effectively, judges and prosecutors have been opting out state jails because of that 60% plus recidivism rate, even when doing so ends up probably incurring some cost to them on a local level. So it does kind of show you that it's this feedback mechanism, that the state policy is really out of step. So I think that we have a real opportunity to look at totally phasing out the state jail system. It doesn't necessarily mean all the state jails would be closed. Over half the people in them now are people sentenced for third or higher degree felonies. And of course, we need a systematic kind of review of all the facilities. You'd want to close those that have the most capital needs, that have some like in the Panhandle that are very difficult to staff consistently because of a lack of available workforce locally. But definitely there have been interim charges over the years. It's pretty clear there's a consensus that in all of the interim reports that the state jail system should be revamped. So that's another area of great importance. One of the other areas, and these are all part of actually the Texas Smart on Crime Coalition agenda, which we're a founding member of, along with Goodwill, the Texas Association of Business, and other groups. But another part of that agenda is geriatric or medical parole. So even before COVID, there were, in 2019, over 500 people passed away in Texas prisons, but only 60 were approved for medical parole. Some actually died while they were in the process. So the criteria are very narrow that are in current law. And so, for example, one buckets that someone can qualify for medical parole is if they're within 6 months of death. And of course, it's not always clear that somebody is within 6 months of death, even though they turn out later to have been. Really, the focus of the inquiry needs to be on whether, due to their medical condition, they're not in a position to be a substantial threat to public safety. And so we're hoping to adjust those criteria. One of the other issues that's also on the agenda is a second look for youths that have been sentenced to what were previously life terms, and then after the U.S. Supreme Court decisions, Texas in a special session changed it to a parole review after 40 years. So we're talking about those that were 15, 16, 17, et cetera, when they committed a terrible crime, often homicide, and that certainly should be understood. But if it's 40 years until they're first up for parole, then they're 57, 58, 59, maybe older, depending on how long the case took to be processed, could be in their early 60s. It's a tremendous amount of time. And we've actually had a lot of research come out, particularly a study that looked at juvenile lifers from Philadelphia and found no recidivism of those that had been released in terms of any serious crimes. So we think the parole board ought to have an opportunity, no guarantees, but to look at candidates after 20 years to see if they've been rehabilitated, if they're a different person, and hear from the victim as well. Absolute right for the victim or victim's family to be part of that and provide input. But it was really interesting last session. Some victims and survivors and families of them came forward to actually support the legislation. So I think it's something that with everything we've learned, it's important to realize, of course. Another topic we're working on for next session is bail reform. And so Chief Justice Hecht has really led the way on this. He's emphasized that the current system is both under-inclusive and over-inclusive. So you have a greater number of individuals who are low risk, who simply can't afford bail, in some cases low as $500, and languish in jail, even though an objective risk assessment would show they're not a danger to public safety based on not having previously had a violent conviction, not having previously absconded, and so forth. So then you have individuals, on the other hand, who are a terrible danger to the public, but are very wealthy and are able to post a high amount of bail. So there aren't as many of those cases, but you have someone like Robert Durst, who dismembered people, but had millions of dollars to post bail. But you also, even more recently, a year or so ago, there was, it's really hard to make this up, but there was a child sex predator in jail and had prior sex offenses, and his mother won the lottery while he was in jail. So all of a sudden he was able to post this bail for hundreds of thousands of dollars and get out of jail. It was literally his mom won the lottery during that time. So it really just does emphasize the current system is not rational. So what we're really working on is legislation very similar to Chairman Whitmire's bill, which was also had a Republican author in the House last session as well, that really would move to more of an objective assessment and having decisions be informed by that. Now, judges would retain the ultimate decision about whether to say someone should be released pretrial, and if so, what conditions should apply, whether financial or otherwise. But it would be informed by an objective assessment. And certainly what we, to really, I think, fully solve the problem, we need the companion constitutional amendment to allow for preventive detention after due process in certain cases. Currently, for example, the Texas Constitution says a judge can deny bail for capital murder, but not for murder. And if you have a preventive detention statute with, of course, the ability, which does exist now, to immediately appeal it, and it's actually fast-tracked to the Court of Criminal Appeals. So you have, and you need to have a hearing with, counsel on each side, a full airing, before there's an order that they're going to be detained prior to their trial. If the judge would find that that's no conditions of release could possibly reasonably assure public safety, and that hopefully that the person, there's clear and convincing evidence that they're guilty of what they're charged, which is important too. It ought to be higher than probable cause, but you have that as a mechanism to deal with individuals that need to be preventively detained, rather than now where as I said, in a murder case, not capital murder, the court's only option is to almost intentionally set an unaffordable bail amount, which really is a perversion of the original intent of bail, which is a method of release, not of detention. And we think that it's important to separate the in and out decision from the decision about the conditions, including any financial conditions. So that's the essence of bail reform. And then perhaps the issue that got the most attention last session was, of course, the Sandra Bland Act, and of course will be part of a broader discussion on policing reform this session. But as many may remember, the House last session passed in a few different ways the bill to essentially say that you couldn't be arrested for fine-only traffic violations unless there was a breach of the peace or an imminent danger to the officer. Unfortunately, that was not taken up in the Senate, but there are thousands of cases. Again, it's as a total of all traffic times people are pulled over for traffic violations, it's a small percentage, but it's still thousands of cases every year. For the most recent, that individuals were brought to jail for, of course, in the Sandra Bland case, she failed to signal a lane change. But also you have other types of traffic violations as well. Other than speeding or an open container, as long as you're under 100, I believe, you can be arrested within the discretion of the officer to arrest for any reason now, rather than issuing a citation. And really, when you tell people outside of Texas you could be arrested for routine traffic violations, they're fairly astonished that a broken tail light, for example, could land you behind bars. So we're really hopeful that will be acted on next session as well. So I think, as we look at the big picture, we don't know, what the bandwidth will be next session in terms of how things may be structured differently due to COVID. But we really think that based on some discussions we've had with leaders, particularly on the finance or appropriations committees in each chamber, that to the extent that certain correction strategies that I've talked about for dealing with technical revocations and drug sentencing and so forth that could have a positive impact on the budget, that there will be an opportunity to fast track some of those, regardless of what limitations there are and how many bills can be heard or such next session. So I am very optimistic. I think we've seen a lot of upheaval nationally, less so perhaps in most parts of Texas. But at the end of the day, everybody wants a safer society. Everybody wants equal justice. And the good news is, despite the spike in homicides, which is really regrettable in a number of cities, as well as domestic violence, crime more broadly, when you look at even other types of violent crime and property crime, actually has continued to be stable or actually slightly declined during the pandemic. And obviously there's the issues with domestic violence as well as overdoses are just absolutely tragic and magnified when people are, at home for long periods and going through very difficult times. And so, but by and large, especially here in Texas, we've still seen crime, again, with the exception of the homicide spike, be at historic lows, really not this low since the middle 1960s. So we don't want to jeopardize that, but we also want to make sure we take steps next session to really continue taking a smart approach that's, both combines accountability as well as a concern in terms of providing avenues for redemption and reintegration, and is not too tough on taxpayers. So I think the mediation program in Lubbock is just one of many ways in which Texas has been a beacon for the rest of the country when it comes to innovations in criminal justice. So I very much hope other counties will move forward with their own versions of that. And we certainly look forward to working with everyone around the state to continue to make some positive progress on these topics. So thanks so much for having me, and I look forward to your questions.